regarding the rules already covered in the previous subsections. So what I'm going to do is first read the facts of the question and then walk you through how to respond to it. So question number 1 reads, an attorney agrees to represent a plaintiff in a negligence case on a contingency fee basis. After the client retained the attorney realized that he needed the assistance of someone who was more familiar with the complex medical issues that were at issue in this case. The attorney thus consulted an attorney who had specialized in medical malpractice. The 2 attorneys agreed that the other attorney would assist with the case to the extent needed, and that the attorneys would divide the fee proportionally to the services performed by each attorney. The plaintiff was not told about the arrangement. Once the case was concluded, the attorney provided the plaintiff with a statement that explained the fee division. The total fee was reasonable. The question asks, was the arrangement between the 2 attorneys proper? So to stop there, I would like to walk you through our approach to answering questions. So far, you realized that I read you the facts, I read the call of the question, and then I paused. At this point, you should get in the habit of asking yourself, what rule are they testing here in this question? And then try to articulate that rule and apply it to the facts. This is really helpful because it's getting you in the habit of reaching a conclusion on your own before you hop into the answer choices. Then, if you've tried to reach this conclusion on your own, you would then look at the answer choices and compare those choices to the answer that you've already articulated to yourself to see if one matches. This is really helpful, and I think it's an approach that while it might take you some time, it's going to help illustrate to you what areas of the rules that you are stronger with and those other areas that you're struggling with. And that's okay. That's why we practice. But again, I think practicing correctly will yield a better result than just going through the motions and guessing. So turning back to our fact pattern here, what rule is this fact pattern testing? What this question is testing is whether or not lawyers can share fees. How did I pick up on that? Because here we're told that a client has basically retained a lawyer. The lawyer realizes that they need some more help with this case, reaches out to another lawyer who assists, and then basically at the end of the day is asking if this was reasonable or if this was okay. So what is the rule regarding lawyers and their ability to share fees? The general rule is that lawyers shall not share fees with another lawyer, but there are 2 exceptions. One exception is that lawyers in a law firm can share fees with one another. But here, based on our facts, those are not presented. We are not told that these are lawyers in the same firm. So that exception is not applicable. The second exception says lawyers not in the same firm can share fees if the following 3 requirements are met. First, the total fee has to remain reasonable. Second, the client has to be informed about this and consents in writing. And third, the fee split between the lawyers has to be proportional to the amount of work that they have done, or they have to take joint responsibility for the matter. So let's apply that to this fact pattern that we have to see if we can reach a conclusion on our own. We're told by the facts that the total fee is reasonable. So that's good. We know that that's an element that's necessary and it's been satisfied. Second, based on these facts, it tells us that the attorneys would divide the fee proportionally to the services that each performed. So that's been complied with. Now we just have to see if the client was informed about this and consented to it. And in fact, we're specifically told that this plaintiff or the client was not told about this arrangement. So we know that that requirement was not satisfied. So that ultimately yields the conclusion that this arrangement between the 2 attorneys was not proper because the client did not consent to this type of arrangement. So turning to our answer choices, let's see if one of them matches. Answer choice A says, yes, because the fee paid by the plaintiff was reasonable. Well, answer choice A is wrong for a few reasons. First of all, the answer to this question that we're looking for is a no answer, not a yes answer. We know that what the attorneys did here was not proper. But second of all, A is kind of missing the point. Though the whole fee might be reasonable here, that's not what this was specifically testing. We know that it was reasonable and that's great, but it also requires that it be proportional and that the client consents. So A is wrong. B says yes, because the attorneys divided the fee in proportion to the amount that they each worked on the case. And again, this is a yes answer and we're looking for a no answer, so it's wrong for that reason. But second of all, it doesn't matter that the fee is proportional. Again, that's just one of the 3 requirements, so B is wrong. C says no, because the plaintiff was not advised that the other attorney was working on the case. So C looks really good. That's exactly what we articulated. So let's hold on to C, but of course we want to double check D to see if D is correct. D says no, because the attorneys from different firms were not permitted to share fees. And D is incorrect, because we know that generally lawyers shall not share fees with other lawyers, but we know that there is an exception. So D is incorrect, making C the correct answer. The second question reads, a family law attorney and a therapist frequently referred cases to each other. One day, the therapist approached the attorney and asked the attorney to form a partnership with her. The therapist had a very good reputation in the community. The attorney also had a good reputation and was known as being honest, competent, and giving candid advice. The attorney agreed to form a partnership with the therapist, provided that only the attorney gave legal advice. The therapist agreed to this arrangement. The firm's stationery and website were changed to reflect the partnership and to also reflect the fact that the attorney is the one licensed to practice law and that the therapist is a certified therapist. The call of the question states, is the attorney subject to discipline if he enters into the proposed partnership with the therapist? So here this question is testing whether or not lawyers can enter into partnerships with non-lawyers. And here the rules state that lawyers cannot enter into partnerships with a non-lawyer if anything that the lawyer does is considered legal services. Here, based on these facts, it looks like the lawyer is supposed to be giving legal services, the therapist, the other partner, is supposed to be giving therapy services. But the problem is the lawyer is partnering up with a non-lawyer and still going to be offering legal services, which would amount to a violation of the rule. It doesn't matter that only the lawyer is giving the legal services. What matters here is that the lawyer is in a partnership, and part of what the partnership is doing is rendering legal services. So, turning to the call to question, it says, is the attorney subject to discipline if he enters into the proposed partnership agreement with the therapist? And we would be looking for a yes answer because the rule says that you cannot enter into a partnership with a non-lawyer if you're going to be offering legal services. So we'd be looking for a yes answer that says something like yes, because the lawyer is still going to be lawyering or offering legal services. So turning to our answer choices, A says yes, since one of the activities of the partnership constitutes the practice of law. Well, that looks very good. That's much like what I told you we'd be looking for. So let's hold on to answer choice A, because even if we think it's right, you should still assess the other choices to see why they're wrong. Answer choice B says yes, because the agreement constitutes a reciprocal referral agreement. B is incorrect. This is not a reciprocal referral agreement. A reciprocal referral agreement under the rules is where two professionals basically refer clients to one another. Here, that's not what's going on. These people have actually formed a partnership, or they would be forming a partnership under this proposal. C says no, because both the attorney and the therapist are competent in their fields, and their letterhead and website make it clear that only the attorney provides legal services. C is wrong because it misses kind of the point of the rule. You cannot be a lawyer offering legal services in a partnership with a non-lawyer. It's that simple. So C is wrong. And D says no, so long as the therapist does not provide legal advice to clients. And again, D is much like C. It kind of misses the point of the rule that's being tested here, making A the correct answer. And then our final question for this segment reads, an attorney represents a client in a contract dispute. The case has been going on for 2 years and is set for trial in 3 weeks. During the course of preparation for trial, the client has disagreed with every tactical decision that the attorney has made. After the most recent disagreement, the attorney felt angry and annoyed at the client and suggested to the client that she seeks a new lawyer. The client was initially upset, but later agreed to seek new counsel. The attorney gave the client appropriate notice to find a new attorney and then asked the court for permission to withdraw. The court, however, denied the attorney's request. The call to question asks, may the attorney withdraw from representation? So, getting in the habit of asking ourselves, what rule is this question testing? This question is testing how does attorney withdraw? Not necessarily can he or she withdraw. And by that I mean, this is not testing whether or not this is a mandatory withdrawal situation or a permissive withdrawal situation. And in fact, just to reflect on that a little bit more, it sounds like here this would be permissive. This is not a scenario where the lawyer's been fired. This is not a scenario where we're told that the lawyer's mental or physical ability is impaired. And this is not a scenario where we're told that the continued representation would result in a violation of law or the rules. So again, this means that it would be like a permissive withdrawal. But we also know under the rules that if you are going to withdraw, you need to follow your jurisdiction's rules regarding withdrawal. Usually that requires notice and or permission from the court. And we're told in this fact pattern that this lawyer does kind of follow these procedures and seeks permission from the court to withdraw, but the court says no. So the call to question's asking us, may the attorney withdraw from representation? My quick answer here would be no, because the rules tell us we have to follow the jurisdiction's requirements for withdrawal. If the court says you can't withdraw, well then you can't withdraw. So we would be looking for a no answer that illustrates that. So turning to our answer choices, A says yes, because the client has sufficient time to find a new attorney and agreed to let the attorney withdraw. So this is incorrect because it's missing the point that this attorney has asked for permission to withdraw and been told no. B says yes, because the client's actions cause the attorney to be materially impaired from repping the client. B is basically factually inaccurate. It sounds like, based upon the fact pattern, that the lawyer and the client don't get along, but we're not told that the lawyer is materially impaired. So B is incorrect. C says no, because the attorney's request to withdraw was denied by the court. So C looks really good. That's what we articulated. So let's hold on to C. And D says no, because further representation of the client would not cause the attorney to breach any of the rules of professional conduct or other law. So D is wrong, because what D is basically saying is that the only time you can withdraw from the representation of a client is if continuing to represent them would result in a rule or law violation. And we know that that is not accurate. There are 3 scenarios in which you must withdraw, and all the rest are basically for good cause, for permissive withdrawal. So D is incorrect, making C the correct answer here.